So, Jason, we are going to look at letter of demands and rental collection. And I think one of the things that we really have to have a look at is why is it so important to issue the letter of demand promptly after the tenant has defaulted? What is your guidance and advice there?
Hi, thanks, Elise. So, the letter of demand following a default on payment is so important to get that out promptly because the first thing it does is that it prompts the tenant to make payment. Where you have a good tenant and you want to have a good relationship with this person, you don't want to have to do all the unnecessary communications. The letter of demand is a standard form document that tells the tenant exactly what they need to do and where they've fallen short of their obligations.
Yeah.
If you can get payment in by just sending a letter of demand, all the issues around the default go away, and it makes the tenant aware of of the repercussions if they fail to pay. So everything is set out in that letter, and everybody understands their obligations and what they need to do.
Jason, and what you're saying is so valuable. And I mean, most agents, they use a system and you have system generated letters. I mean, TPN's letter is very standard, but I mean, it starts the process in motion. So just something interesting from Expella's side is we don't get involved immediately after the letter of demand is done. So for the people that's still new to the Expella services, when you send out that letter of demand, you purely CC breach at expeller.co.za. Lizana is going to pop that in the chat that you have that email address. It's a super important email address. And then we usually wait a week because, as you say, Jason, is many people they get the letter, they go, ooh, and then they make payment. And you don't need to take any further action. But I hope I'm
Yes.
not confusing people because I'm not talking about 7 days. What is the important timelines when we talk about letter of demand?
So I think the timelines that one would need to consider. It's always important as a first port of call to consult your lease agreement. Just make sure that you know the time periods that the tenant would have to remedy any breach. Usually it's 7 days, like you said, that's kind of the standard. And I think the important thing also to understand there is what kind of the lease period, whether that subsists. So if the lease period is still running, you would have to comply in terms of the CPA, which is 20 business days. Most good residential lease agreements would have that clause in their breach clause or in their default clause, which would require 20 business days anyway. But the important thing is to consult your lease agreement as the first port of call to make sure that you understand it and know the time periods that you have to afford the tenant.
So, Jason, I want us to stand still here because I think sometimes it can be a bit confusing. And I think we have to remember that even if your lease agreement says 7 days, but the CPA is applicable, then you have to give 20 business days. So I almost tell the agent, if you are not sure, please consult an attorney or rather just give 20 business days. Because if it's, I think the simple rule, in the fixed term period and the CPA is applicable 20 business days. I think that's the safest port of call. If it goes on a month-to-month basis, it's 7 days. Am I summarizing that correctly?
Yes, yes, you are. So just maybe for those that don't know, the CPA is the Consumer Protection Act. And that's a piece of legislation that governs lots of things that involve consumers and purchasing and the rest of it. But it does apply to fixed term lease agreements as well. So the 20 business days is a legislative imperative. We have to afford a tenant where there's a lease agreement that's still running, a lease period that's still running, 20 business days notice.
Yeah.
And they have that time in which to remedy a default or any other breach.
So, Jason, is something interesting. So, and I think this is also where Expeller fills in the gap. Is an agent will send a letter of demand, and ideally an attorney would cancel. I always am very pro your attorney that's doing the eviction to do the cancellation. And that's where Expeller comes in, and we use that argument like say 15 business days. And the reason why we don't get involved in the first week is to give the tenants, because we see 50% of tenants actually make payment if they receive the letter of demand. If they don't, it means there's a real problem. And that's where Expeller then steps in and start, negotiating and see if we can get them to remedy in this time period. But do you maybe have a few examples for us where swift action, where people took action quickly and it actually helped to resolve the matter quickly or shorten the process?
Yes. So I've experienced many situations where a letter of demand and a letter of demand and a call, have resulted in payment being made and the issue never creeping up again. A lot of times you'll find that it's maybe a cash flow issue, or people were paid late by their employer, or there was a problem with maybe their bank account was frozen due to some fraudulent activity or something like that. And a letter and a call just kind of put the tenant, they understand the position, they understand that they haven't met their obligations. But what the call does is as well, it humanizes the relationship. It says, look, you haven't met your obligations, but I'm trying to understand why. And I'm trying to understand how I can help you and how we can get past this problem. And swift action in that way, it doesn't allow the tenant time to ruminate on it and think, oh, what am I going to say to the landlord? How am I going to explain this? And it
Yeah.
also for the landlord, it solidifies your position and it gives you, the appearance of strength. You're not sitting there thinking, oh, should I call? Should I message? I don't want to ruin this relationship. This person has been a good payer in the past and I want them to continue. So it kind of erases all those questions and it gives certainty to both parties and it gives you the platform to resolve the issue quickly. I think the other thing that swift action does is that you can negotiate. If there is a problem where the arrears can't be settled immediately, the person can say, okay, I'm making a plan, I'm speaking to friends, I'm speaking to family, I can get you the money in a week, I can make payment later this month, whatever the case is. It gives you an understanding. Not to say that you should, just believe them on face value, but it starts the conversation. And the other thing that it does is that it shows your creditors, if your property is bonded, if you have an obligation to the bank, and for whatever reason, you can't then make your obligation because your tenant hasn't paid, you can show the bank, look, I've sent a letter of demand, I'm taking action, and that can buy you time, it can buy you grace, and it shows that you're actively involved in remedying the situation.
Yeah, and I think if majority of agents are that's on here as agents, and I think people have to remember that that's one of the value as an agent you are giving your landlords. You are saying, I'm keeping the finger on the pulse. I'm going to make sure the process runs, and you don't have to get into that conflict. And Jason, I just want to hear from your side. So Expeller don't get involved in if it's not an Expeller client. We get often people phoning us saying, it hasn't been paying us for 5 months now. Can you help us? And we don't get involved in those type of matters and we refer to attorneys. But my overall feeling is the longer a tenant is allowed to stay in the property without action, the more difficult it is to get them out. Do you have the same experience?
Yes, certainly. It's like anything that if you have a small cut and you don't take care of it and you don't clean it and dress it, you can get an infection. And that's inaction, and it's letting time run without any reason. If you don't do anything about it, and I understand, people aren't sure of their legal rights, and what they can and can't do. And it's a normal reaction, if you're not sure, you kind of leave it. And I think it's, all of us do it with some aspect of our lives. But like in your example, when it gets to 5 months, now the arrears have grown significantly. And the tenant, unfortunately, you've created an expectation in the tenant to say, oh, I can actually stay here without paying. My landlord's not doing anything about it, for whatever reason. And that's where in my experience, people become entitled, and they believe that this is something that they can do, and it's not the case. So If it gets to 5 months, I think you should at that point definitely consult an attorney or a legal practitioner, get good legal advice and get that ball rolling, because ultimately the longer it drags on, the arrears grow, and it's just a bigger headache for you.
Yeah, you're absolutely talking truth there. Amanda's actually raising something very valuable. And I would just, and I think we need to address and make sure how this is done. So Amanda's saying, you had a very good tenant always pays on time, and then suddenly they're starting to pay late because of salary issues from an overseas company. And the question is, do they just immediately send out a letter of demand? Or is it better to just make an arrangement to say, okay, well, the due date was the first. From now on, the due date is the third. And to make sure that the payment is made on time. Now, Jason, before I throw the ball to you, sometimes, I see if you keep on sending out the letter of demand, it sometimes just aggravates things a bit more. But then on the other hand, you have the landlord on the other side. So for me, it would be a conversation firstly with the landlord to say, a landlord, we have a good tenant. It's not because he cannot pay, because if they cannot pay, Amanda, the conversation should be, how can I help you to find another place to stay? But say, for example, is it correct to say they can enter into an agreement? And how should they go about to formalize that agreement to change the date?
So I think the first thing is, I don't personally like the idea of many letters of demand. I don't think many letters of demand necessarily take us anywhere. I think a single letter of demand, and like I said, a call and a conversation to understand the problem. So, like in the example where they work for an overseas company and for some reason they haven't been paid. Once you send that letter of demand, they tell you this, and then you say, okay, can I get a letter from your company saying that there's been some delay or some confirmation, just to verify what you're saying. And if we get over that hurdle, great. We can enter into an acknowledgement of debt if you want to formalize the repayment, or if you want to change the date on which your rental is due, you can sign an addendum to the lease agreement so that the obligations are recorded and everybody. Thing is, what we're trying to do in a lease agreement and with letters of demand is all just conveying information. We're making sure that we're on the same page so that we all understand what we're entitled to and what we're obligated to do. So my suggestion there would be letter of demand, a call to ascertain what the situation is, a letter from the company to confirm the position, and thereafter, if you want to enter into a repayment arrangement, acknowledgement of debt so that you secure your rights, or if you want to change the date on which the rental payment is due, to sign an addendum to the lease agreement, just to confirm that in writing.
I think that's the addendum is very good advice. Thank you, Jason. I think that's something we have to remember. Amanda, the other thing that I see, especially if you have an owner that cannot really wait for the rent, they're very dependent. What we did with one of the negotiations, Expella got involved, is we spoke to the tenant and we said, listen, you are, can you not pay upfront a double month? So this month you pay twice. So next month, if you only pay us on the 10th, you're basically going to be in advance a month, because then the cash flow helps. So you get the double payment, and then every month as they pay you, the date that they're paying late, they're actually not paying late. But I know not all tenants can go and pay double rent immediately. It's not a deposit. It's basically I'm paying faster because I know some days I'm going to pay on the 5th and some days I'm going to pay on the 10th. So that's something we did. Then we have, I'm taking these questions because I think it's a very important, it is very relevant. Dawn is asking, when they send out the letter of demand, can they contact the tenant within the 20-day period? Now, Jason, Dawn, I'm going to take this as if it's not an Expella client. If it's an Expella client, the good news is you send a letter of demand and we will do all the work for you. You can do your agent work, you can grow your business. But if you're not using Expella as yet, Jason, what is your feelings? What is your guidelines for an agent when they contact the tenant?
Yes, so just to answer the question, you can certainly contact them during that 20-day period. And I would say that it's very important to establish a line of communication, because when you don't speak to somebody, they create these scenarios in their minds. And, it can be quite anxiety inducing for the tenant as well. So it's always good to pick up the phone after you send the letter of demand and say, look, I know you've received this letter of demand. We're not trying to, be horrible people, and, it has nothing to do with you personally. We just need you to understand that you haven't met your obligation and that you need to make it right. And how can we help you do that? So you can certainly contact them in that 28-day period. And the line that I always take, and the line that I think everybody should take, is, how do we help you?
Mm. Okay, that's very good. When Robin is just saying, when she sends a letter of demand to a tenant, she sends daily repayment reminders as well. Perfect. I mean, that's something you can do. This is, of course, the question, and I spoke to Jason about this as well, is when is the best day to send out the letter of demand? On the 2nd of the month or the 3rd? Jason, what is overall your experience? When is the best time?
So I think it's, if you, like, most rental payments are due on the 1st of the month. I think if you don't get your payment on the 1st of the month, by the 2nd, they're in default. You can send that letter of demand out. I would generally make contact first with the tenant. If it's a good tenant, I'll give them a call. I'll say, what's going on? We haven't received this. What's the story? If you don't get a good enough answer, or if you don't get any answer at all, immediately send out that letter of demand.
Yeah.
Send it out, because as soon as you do, you start the process going. And like I said, you can give them a call even after sending out that letter of demand. And you can discuss with them what the issues may be. But that letter of demand, I'd say, if we're counting from the 1st, when rental is due, the letter of demand can go out on the 2nd, but you can also give them a call before you send the letter of demand. But 2nd, 3rd, I think those are the times that the letter of demand should go out, and as well as a call.
So, Jason, I want to say something, and I just want to add to that. And I think this is also the different advice. So we see, from attorney side, if Jason wants a letter of demand to go out, ideally we want the 20 days to lapse within the same month, that it doesn't go over to the new month, especially if you want to proceed, or you see that you are going to proceed with an eviction. But I've dealt with so many agencies, and that poor administrator, I laugh. I say, I usually see this big red button, and they're sitting there sweating, going, I have to now press this red button, sending out the letter of demand, because everybody's going to start screaming. So from Xpella side, and if you guys are Xpella clients, because remember, in this period, we are going to phone, we're going to WhatsApp, we're going to send at least 3 additional letters. We are happy if you send a letter of demand by the 5th or the 7th of the month, okay? Because we know that you have to allow time, especially if the first was on a Saturday or the Friday, just to give time to reflect, because a lot of people, that poor administrators, they get that backlash going, I've paid, and now you send the letter of demand, and people are very aggressive. Ask my poor Xpella team. They just say hello and they get it. So look at your business, see your model. If you send bulk letters of demand, maybe better to wait until the 3rd, the 4th, or the 5th. Get it out. If you see somebody that repeating paying late, then I would move up it a bit. But again, it's all about your business that makes things. I want to, Jason, what have you seen? Because, with Xpella clients, again, we get the letter of demand and we often see mistakes. And we're there to help them. What is the most common mistakes you see landlords make when they do the letter of demand or they're trying to collect the money?
So, in respect of the actual content of the letter of demand, and I'm sure you echo this, it's always best to have somebody that understands the processes and what they're doing. It's always best to have that person actually draft the letter, because there are certain essentials that you need in there to make sure that your demand is effective. So, if you're unsure, speak to somebody, or try and get advice instead of doing it yourself, because you may set yourself back. So that's a common mistake that I see. Demand can be effective over email, that's fine, but you need to make sure that you have certain essential elements. So needs to be addressed to the right person, at the correct address, email address. It needs to have the right property description. It needs to have the correct amount and the correct time period in which they have to pay. And then you should be fine. But it's difficult where a landlord comes to me a month down the line and says, yes, I've sent them a demand, and it's very disheartening and frustrating for me to have to turn around and say, well, unfortunately, your letter of demand is ineffective for XYZ. And that's a lot of frustration for both of us at that point in time. Another common mistake is excessive indulgences or trying to be understanding without doing anything. I've seen many situations where people have good relationships with their tenants on a personal level, and it could be somebody that's going through a hard time, or somebody that's for one or another reason you feel sorry for them. But because you feel sorry for them, it doesn't mean you should give excessive indulgences, because ultimately it's going to diminish the relationship further when you have to fight down the line. So kind of explain to them why you're sending this letter of demand to them, why they have to meet their obligations, and that it's nothing personal, because you're just going to kick the can down the road and frustrate yourself further. And the other thing is, letters of demand in themselves, unless sent via TPN or credit bureau, doesn't affect a tenant's credit profile. Unless you have a default listing. So that's something else. Landlords sometimes say, oh, I don't want to affect their credit profile, or they were a good tenant before this, I don't want them to have an adverse listing on TPN or anything like that. If you're not sending it through TPN or credit bureau, it's not going to affect their credit profile, so you should send it.
I love that. That's something even I that's why I learn as well. That is so true, because people don't want to always prejudice. But Jason, I have to ask, the emails that you sometimes, when there's letters of demand. I mean, I saw one email and then the landlord's written, do the right thing and pay your rent immediately. That's the type of emails I get, and I go, but where's the demand?
Yeah, exactly.
That type of thing, that doesn't count. So warning signs that you would say, please don't put it in your email. I think excessive capital letters, definitely not in your letter of demand. Anything else you would say to them not to put in their letter of demand?
Yeah, so capital letters, any foul language, it's not going to help you. I would say kind of stay away from emojis as well. The thing is, what you're looking for is to give them certainty. So they need to know the demand that they're responding to. They need to understand which properties it's in respect of, who it's addressed to, and how much. Those are the only things that matter. The emotive stuff, it doesn't really take you anywhere. And in your example, sending an email to say do the right thing. The right thing is maybe subjective. It's not always the right thing. Isn't the right thing to everybody. Across the board.
And I also want to take the advice. Be careful. I know that it's emotional. I'm a landlord myself, an investor, and I don't know why. It's almost like a divorce, and you get emotional. But please stay away from something to say like, old lady, you're not doing what you're supposed to do. Or because one thing we have to remember, and I always taught that to my candidate attorneys, or if I speak to somebody, is that letter is not really, yes, it's intended for the tenant, but you want to use it in court. So if the judge is going to get a letter where you are very rude to the tenant, instead of just coldly cleaning, setting out what you want, it is going to look badly on you. So I always say this is general advice. Type that email, delete it, and then use a proper TPN letter of demand if you need to. Okay, so that's something that one should have a look at. Then we send the letter of demand, and Jason also said something very, very important. Please address it to all the tenants. Don't just address it to the party that you speak to. So if you have a husband and wife and you always communicate with the wife or the husband, please address the letter of demand to both the tenants. Jason, what happens if you don't address it to both and you only address it to one party?
I think that's a very interesting question. And again, it goes back to the starting point. is always to consult your lease agreement and make sure you know who the tenant is in respect of the lease agreement. Because if you have a family of four that are living in your property, it could be that it's just the father or just the mother that's the tenant, and the other occupants may be listed in the lease agreement, maybe not. But your contractual relationship is with the tenant. So that's the most critical person. You need to address it to the tenant. If you are aware of other people in the house, if you know their names, you can address it to them as well. And that's probably the safest route, is to address it to all the people that you know are occupants in that property. But it's critical, it is vital to address it to the tenant, the named tenant in the lease agreement.
So, Jason, many years ago, what happened was we actually did there was a letter of demand. This was when I was still in practice. We worked with the agent, and I don't know how this happened, but the letter of demand went out. It was cancelled for one tenant. And then we realized, but there's another tenant. And that other tenant actually turned around and said, well, I'm still legally in the property because the lease agreement wasn't cancelled for me. And it was boyfriend and girlfriend. And so basically you can evict the girlfriend, but she's just going to stay with the boyfriend and nothing happened. So you don't want to, I think, Amanda, that's the important part, is that you make sure that if you cancel the lease agreement, that you cancel it for all the tenants. Because otherwise you don't want to have a situation that one person is legal in the property, the other one is illegal. It's going to cause a delay. And I know some systems, they don't pick up all the tenants. So please make sure when you use the system and the letter of demand goes out, even if you have to send 5 letter of demands to each and every tenant, please do so. And then just keep all of them together, that you have that proof. Now, time
Sorry,
flies when
Elise,
we have.
if
Yes.
I can just come in there, just, there can be situations where, for whatever reason, you don't know who is in the property, and you have a suspicion that there are people that maybe shouldn't be there, people that aren't named in the lease. If you have that suspicion, I think in your letter you can address it to Mr. X and Mrs. Y, the tenant, and all unlawful occupiers, because
So
that
just
will give you some sort of protection as well.
But Jason, just for interesting sake, I mean, for the lease agreement to be cancelled, technically they only have to demand from the tenant. But
Yes.
ideally, you want to inform those occupants because you want them to vacate, or they need to put pressure on the tenant to make payments. That will be the purpose of sending a copy of the letter of demand to the occupant. Okay?
Yes, exactly.
Just to, because people always ask me this, we are not contravening POPI or something if we send the letter of demand to the occupant. The tenant can't turn around and say, hey, you're not sharing my information, the occupant is not supposed to. We're not going to get in that type of trouble.
No, no. So most monolease agreements would have the release in terms of copy anyway, but in vindicating your property, in kind of enforcing your rights, you can send that letter out.
Okay, fantastic. So I love what you are saying. Absolutely. If you know there's another occupant, send a letter to them as well, because the more knows, the more can put pressure or make sure that payment is made, because they're quite sure they don't want to be evicted. Now, we send out a letter of demand and they haven't performed. What is the next step?
So if they fail to remedy their breach, and the least and the time period that they had to remedy their breach, be it the 7 days or the 20 business days, has expired, you've got a choice to make. And for me, I think it's important that you actually you make that decision, whether you're going to just chase the arrears and collect on the amounts outstanding, or if you need your property back, if you don't want these people in the premises anymore. At that point, I think it's important to cancel the agreement. You do that by letter, and thereafter consult a legal professional on assisting you with eviction, if necessary.
Okay. So today's talk, we are going to touch more on the summons part, trying to get the money in. So the first thing that I have to, because this is important for me to convey, because I don't think a lot of people know this, and we're deviating a bit, having fun on the questions. But if somebody starts with the legal process to summon someone for the outstanding money, is there a guarantee that they're going to get their money?
No. So unfortunately, there are two legal concepts. So there's prospects of success, and what that means is a magistrate or a judge will find in your favor, and then there's prospects of recovery. Now, prospects of success, 9 times out of 10 with residential lease agreements, whether you're seeking a rear rental payment or eviction, you're going to get your order. And when it comes to eviction, we always say at Hadar Incorporated that it's a question of when, not if. Because if you can show that that's your property and you can show that they don't have a lawful right to be there, you will get your property back. The difference is with collecting a rear rental. If there is no money, where are you collecting it from? It's difficult to draw water from a stone. If it's a man of straw and they truly have nothing, you can get your judgment, but that doesn't necessarily mean that you're going to receive the rear rental back, unfortunately.
Yeah. And Jason, just tell me that judgment, because I mean, a blacklisting sort of disappears after a year or two. How long is the judgment in place?
So a judgment from a magistrate or a high court lasts, if unsatisfied, for 30 years. So in that 30 years, you can collect on that amount outstanding, and it will continue to affect their credit profile.
And that is absolutely amazing, because if you think about it, normally, if you're not a TPN, if you don't list it, a lease agreement isn't a credit agreement. So those defaults don't reflect on Experian, Versailles, or any of the other credit bureaus. So, but if you have the judgment there and they can see it for rent, at least you are warning all other people as well. Hi.
Yes,
Okay.
exactly. The judgment debt, it affects a lot more than just your credit record as well. It can preclude people from holding certain positions in companies and getting employment in positions of trust because you've shown yourself unable to meet your obligations.
Oh, Jason, that's a very good one to stipulate, hey? Armand always tells the story of the person that was working in the bank. And when we said to him, listen, we're going to tell your bosses that we're going to get judgment against you. And he actually vacated and paid all the money. So what you're saying there is very, very valuable. But now, a lot of lease agreements say that tenant will be held liable for the legal expenses for a summer. But you and me know that an attorney actually needs a deposit first, hey, to do the legal work, and then you hope to get your money back at the end. So I'm saying proper because I know, I don't know, there might be attorneys that don't take a deposit. I just say with the attorneys that we work with, and I mean, Hadar give Expella clients a very good fee structure if it's just to issue the summons. And I can also say, Jason, sorry, I'm from promoting that they're not going to be those attorneys that just going to keep on asking you for money to chase money if they know you're not going to be able to recover. I saw people that keeps on getting writs and chasing people, and they spending more money. But now, if I paid 10,000 rand, and I'm not saying that's your fee, if I spend that on legal fees, will I get my full 10,000 rand back?
So that's there's various factors that affect that. Your legal fees, yes, as a landlord under the lease agreement, if you have to take action to recover your arrears or even to evict them, you're entitled to those legal costs. But the way legal costs work, as you know, is you're not entitled to it even at the point of judgment. You can't send somebody to say, okay, this is, you bring your attorney statement and say, this is how much it costs me. No, so you'd have to get those legal costs taxed, and thereafter you'd be able to collect on them. And like you say, an important thing to know before you get any service, you'd go out and ask for a quote. You'd go out and kind of understand what you're trying to pay. The way we work at Hadar Incorporated is that, like you say, we have a set fee structure for matters where it's unopposed or undefended. So you know exactly what you're going to be paying before you instruct us. And we find that for a lot of the landlords that we represent, it gives them a lot of certainty. It allows them to budget and it allows them to plan, so that they know, in a nutshell, what the expenses are going to be, and when they'll be able to receive the judgment and over what time period when those payments become due.
So, Jason, I want to say that's why I applaud, and that's why we are very happy to have you on our panel. Is if attorney should be able to tell you what is the estimate cost. I'm not saying it's a guaranteed, but the estimate cost. If an attorney can't give you that breakdown, it means they're not doing it enough to have that experience. And hard on them, they specialize in this type of work, and that makes it very, very easy for them to tell you what to expect and what is the time period. So, of course, and this is, I see Kim asked a very good question, and I'm going to address it, but I also want to sort of capture that with my following question dealing with the summons. So you issued summons for the outstanding rent. Say, for example, the lease agreement has not been cancelled. And we sued them for outstanding rent up until the end of April. Is May's rent included in that summons?
So we generally do what's called a full house. So
Okay.
so it's arrear rental and holding over damages, until they vacate or until the lease period expires. So it's separated into two parts: the arrear rental, which you would get immediate judgment on, and the holding over damages need to be quantified. So that's the point at which the premises is returned to you or the lease period expires. And that it runs on a daily basis. It's like a ticker, each day that you're in the premises, it's whatever it is, 500 Rand. And once that amount becomes quantified, once they leave, then you can go to court and say, this is the amount, and you get judgment for that amount.
Jason, I laugh and say, as an attorney, I'm very bad with math, but that's one calculation I always can do. And what we usually do is you take the rent times by 12 and divide by 365, and you have your daily rent.
Yes.
But you can only ask that if you cancel the lease. Hey, if you haven't
Yes.
cancelled the lease, you can't offer a holding over. And technically,
No.
then what has to happen is you have to issue a new summons every time. If you're
Yes.
only asking for the rent. So I think it's very important to take the right step. And a summons does not automatically mean an eviction. Do you agree with me? Just interested sake, because with us, you always do an application for the eviction separate to the summons. Do you ever do an eviction as part of a summons?
No, we don't, because it can get quite it can get overly complicated, where there's disputes. And with a summons, ultimately you could be heading to trial, and you don't want to be heading to trial where an eviction application is tied up in all of that. The application process is much easier, much simpler. You get a much sooner hearing date, and it also allows the tenant to make representations a lot sooner. So you get resolution a lot sooner. So yes, I agree. I would definitely keep those separate, just to at least ensure if there is some kind of proper opposition to your summons, that your eviction, you can still get your property back, and you're not going to have somebody squatting there indefinitely.
Okay. And for Expello, people that's not with Expello, you don't have to issue a summons to proceed with an eviction. It's a choice. I know that actually, I heard somebody told me, an attorney advised them, you have to issue a summons, otherwise you can't proceed the eviction. Jason, am I correct? That's not true.
No, it's not. You can, and we have for many years, brought successful eviction applications in all the magistrate courts throughout Gauteng, and in high courts throughout the country, actually.
So just to tell people, I think this is another opportunity where I'm so excited to share what is Expello's new add-on. So Expello know that our client bases are growing, and we are forever looking at a new way to make things faster, better for our clients. And although I don't believe that if we issue summons and judgment that we are going to get money back, but to help and put extra pressure on the tenants, in the event Expello is proceeding with an eviction from now on, Expeller will issue the summons on behalf of the owner at Expeller's cost. I mean, I think that's a great value add. So if we instruct Jason and them to proceed with the eviction, we will also instruct them to issue the summons on Expeller's account. And the reason for this is purely to put more pressure on tenants. We are seeing more tenants taking chances these days. We are seeing matters getting more opposed, and that summons will put more pressure. Jason, is that your experience as well? That if you issue the summons and the eviction together, it puts a bit more pressure?
Yes, definitely. If I can give the example, it's like fighting two people at the same time. You know, you're fighting the summons and you're fighting the eviction application. It's difficult, and for the landlord, you're going to win. You're going to win on one or on both, and the pressure on the tenant, in that situation it's immense. So a lot of times you get your result.
So we are not just giving extra value add, we are also saving you a minimum of 5,000 Rand for our Expeller clients. And like I say, we are really trying to see how we can solve it. Time is going back, and I just want to take one step back to the letter of demand, Jason. Sorry, I know I'm jumping a bit, but we've got a very good, like I said, Kim is asking a question, and we see this where people don't understand. You send the letter of demand, they remedy the letter of demand, and then they default again. Is it correct to say you have to issue a new letter of demand?
Well, again, it's going to be dependent on the lease agreement. Most lease agreements will have a continuous breach clause. So if somebody breaches it's usually 3 times or more than 2 times in a 3-month period, you'd be entitled to cancel. Because I see Kim's question is very good. If you have somebody that's consistently a late payer, but they remedy within the period, you're just going to have this constant headache. So there's generally a continuous breach clause. If there isn't, you can make submissions on the basis of continuous breach. But that's a more legal kind of technical point for further down the line, and you should probably speak to a legal professional about that.
Jason, just to ask, have you ever been able to do an eviction solely on the ground of continuous late payments?
So it's strange, that one, because I've never actually had to do an eviction on that basis. Because there's usually other factors involved, and generally the people have the money to pay. If they're just making late payment, you can change the due date for the rental in order to accommodate them. But if they're doing it just to be, I don't know, difficult, it's quite an interesting situation. And I think it's difficult to say without having an agreement in front of you or understanding what the relationship is between the parties.
Yeah.
But yeah, I see no reason why, if you could make the appropriate submissions to a court to say that notwithstanding that there isn't a continuous breach clause in the lease agreement, which is the only circumstance in which I imagine this could actually happen, you could say to them that they're doing this, to be vindictive, to just frustrate me, and as a result, I don't want them in my property anymore. That's reasonable, but you'd probably have to address that in a letter to them as well. So it's difficult, but that's probably how I go about it.
So, Jason, sorry for putting you on the spot on that one. And I know usually it is not just late payment, there's enough other grounds that makes the cancellation much more clean. So, Kim, again, if it's an Expeller client, what we usually say is maybe skip a letter of demand that they are 2 months in arrears and then demand, because it's much easier to catch up 1 month than it is to catch up 2 months. So that's one strategy that I sometimes discuss with my clients to see if they can sort that out. That's the first one. The second thing is, from Expeller side, we are not comfortable to just cancel and evict on solely the ground of late payment. We haven't found actually any attorney, because usually if there's other grounds, yes. But just on that ground, we are not comfortable, because on the one side, the tenant can argue, but that's why there's a breach clause. The breach clause is there to say that if I breach, you have to put me on terms and I can remedy. it can see a substantial ground, but we are not confident only on that ground. So what Expello does is, if it's an Expello matter, we really go into it and we see how, how to substitute, to set it out properly, that we're not going to have a problem in court. Because I have to say, with attorneys, and Jason will agree with me, one can argue it in many ways, but we deal with people. And nationwide, I mean, we go to many different courts. You have to know who's that presiding officer, and if that presiding officer is going to entertain it. If you have a very strict presiding officer, they're not going to just grant it for you because of late payments. They're going to say, okay, so what prejudice did you suffer? Oh, but did you charge penalties or whatever? So you're not actually, you got your money. So I do think this is something that we will always discuss with any of our panel attorneys and go, you know the judge, you know the magistrates in those courts. Is it something we can take a chance with, or is it something that we don't take a chance with? Remember, I don't like, it's almost like an operation. I don't like taking chances because at the end of the day, it's not my property. I'm not the one losing income. But I don't want to play with the landlord's loss of income. It doesn't feel that right place. If it was a big corporate saying, I don't care if I lose money and I will do it out of principle, yes, I will go and test it. So I don't say take out the clause. I know that that clause is in standard in all the TPN leases, and it's a good clause to have. It helps us when we negotiate and we want to place the people on terms. But to solely cancel and evict just on that ground, I haven't been confident enough. And maybe I'm conservative, but we are there to protect. So, but we'll have, for example, the conversation with Jason, say, listen, we're going to this court. We want it. This is the chance. And then we say to the landlord, is this a chance you're willing to take? Because again, eviction these days, it takes how long to get a court order? About 3 to 4 months, Jason?
Yeah.
So you're going to take 3 to 4 months to get to court, to get your order. And if you are only 80% sure or 60% sure, I would have rather used that as a pressure point on the tenant. Change the strategy a bit. Make sure we get a clean cancellation that cannot be open for dispute. So that is only the thing on our side. Robin, thank you for the clause that you have set out there for us. So an hour has gone past so quickly. Jason, just in your experience, overall, what is your last parting points or things, information you would like to share with our audience today?
So I think the last thing I'd want to share is actually stepping outside of my role as an attorney and stepping into my role as a landlord, because I actually have a small apartment with a tenant, and I recently got in a new tenant, and it's always that first month, the first month rent that's due. And I don't know about you, but I've always, you're just a little bit more anxious than you were with your previous tenant. You're hoping that it's going to come in on time. You're hoping it's going to be the full amount, and you're hoping for no issues. And she did. She made payment, and it was all fine. But what I've discovered is that consistent communication, not constant, consistent communication, good communication, being on good terms with your tenant, understanding what's going on, kind of it doesn't let problems arise, because when there's an issue, they feel like they have a good relationship and open communication with you, and that's worked really well for me. But stepping back into my attorney role, when the issues do arise, take action. Don't let it fester. Don't let it sit. Consult somebody, speak to somebody, take the appropriate steps to get yourself back in a good position and to generate income from that property as soon as possible.
Jason, that was so valuable. Thank you very much. And I shared Hardart Incorporated's details on there. There's their office number, there's their website. If you contact them, you can be in contact. But please, also, let's respect the attorneys. Now, this is a bit of a caveat, but I can say this because I have to protect my attorneys as well. Please don't just keep on phoning them for free advice. Their time costs money. So if you have a client, make them provision to say, listen, we want to take legal action. Keep in mind there is going to be a deposit due that we use them for the right things. But they're always there to help. Jason, thank you very much for your time. The details are on there. If it's not an Xpella client and you want us to refer to them, send us an email. We'll CC Jason in there and his team. Make sure you guys get to the right hands. Jason, from me and the Bridge team, the Xpella team, we want to say thank you to you for your time today and to Hardo Incorporated for always looking after our clients so nicely. We really, really appreciate it.
Great. Thanks, Elise. Thank you for having me on. And thank you for being the good brand ambassador that you always are. We love working with Xpelo, and we hope to partner like this again a lot more in the future.
Fantastic. Thank you, Jason. And then just by ending off today, our next webinar is next month. I want to say it's the 14th of June, but now I'm not sure. I've written it down, but we'll share those details. I think we definitely need to talk about the CPA again. So we'll have our guest speaker, then we'll have an attorney from Van Deventer's offices online next time. They're also on our panel, and we hope to see you there. We also, before I forget, we are excited to share that we are starting a chat group. Okay, so we actually often see people saying, Elise, we didn't get the email, we don't know what's going on, we share valuable information, things from our clients, and they don't know. So please, Lizanne has shared the WhatsApp link there. Click on the link, become part of our group, okay? We'll make sure that everybody gets the information. We'll share valuable things that's going on there. We are not going to flood you with nonsense. We will not send you a good morning and a good night message, okay? We know you are busy people, but I think it's important that we share. So please join us. I hope you will get value from that, and we'll see you next month. Keep well and be safe and stay warm.